Yes, Mr. Gordon.
Lord, the quick answer to one question which was left to me just before, the instructions are to invite this court to remit to the appropriate tribunal.
Do you have any submissions as to which is the appropriate tribunal? I mean, I suppose the starting point would be simply to remit back to the UT, since that's where it's come from. Would you suggest anything different?
If we win on the auto-cleanse point, but don't succeed on the second part of our respondent's notice, then it might be more appropriate to remit to the First-tier Tribunal, because it's finding of facts that are
all right.
But I have to accept, I think we should accept that there's so many permutations, but that's why I'm leaving it to
right. So what you would say, it depends on what the grounds are.
Absolutely.
Yeah. All right. That's logical. Thank you.
Subject to that, if I can just continue with where I left off. Now, it's a case of counsel asking the bench for direction for signposts rather than the other way around. I was dealing with responding to ground one of them, but I believe we seem to have moved into ground two. Can I just check that is indeed your lordship's understanding, or do you think we are firmly in ground one still?
Well, I'd understood that we were trying to define what the test correctly was, and the extent to which the either of the tribunals had departed from it, specifically the UT. And in doing that, we'd obviously begun to consider what the UT's process was. So I think probably we have moved into ground two, unless you're unhappy with that.
No, not at all. There was just one point which actually does bridge the two together.
Yes.
And what we say, and we'll make the submissions by reference to the facts of Hall and Lorimer because they are quite extreme. The natural consequence of HMRC's case is one looks at one particular contract under the microscope. So Mr. Lorimer, one particular television production company. Look at that, without taking into account the wider picture that he is clearly carrying on self-employment. One looks solely at that without including into the picture that wider, the wider self-employment. I would submit that a typical provision of service in that circumstance is going to sell through stages 1 and 2 of ready-mix concrete. And then when put in the context of stage 3, is there anything inconsistent with this to make it self-employment? If one puts a too narrow focus on, too small a frame, the answer will also be no. So Mr. Lorimer's first contract of the year, or whatever period one's looking at, will fall as an employment.
So, broadly speaking, that a decontextualized focus on the terms of a contract only, in that case, a short contract, makes it highly possible that one will reach a perverse conclusion.
Indeed. And I will say that applies. The reason why it has to take that step back and look at the wider trade, profession, applies in all cases. And then it's simply a matter for the fact-finding tribunal, decision-making tribunal, then to see how this particular contract fits into that picture. And that's my ground 1 point. Moving into ground 2, what we say is that the Upper Tribunal's decision can be defended on ready-mix 3. We did start the analysis looking at paragraph 112 onwards, but if I could invite your lordships to look back at 109. For completeness, let's go to the beginning of stage 308, but that's merely introductory.
Yes.
We have, starting at 109, we have a reference to the First-tier Zone decision, 110. We have other references in the next 6 paragraphs, in the next 2 pages, of references to what the First-tier has said. Upper Tribunal had clearly in mind the facts that the first tier had itself reached and were not impugned by the autoclave. And it was considering them. And what the Upper Tribunal has done, rather than list 6, 7, however many facts it considers relevant, it has taken what I say is the logical starting point of identifying the wider trade. It kept reminding itself it's not determinative. And it was like a pendulum. It was saying, well, is there enough to pull it the other way? And it was going through in 2 pages of fairly dense text rather than bullet points, an analysis of all the things that could pull it away from being part of that trade and being a separate engagement and separate employment. So given the fact that it had made a number of findings reliant on what the first tier had said, as I said, there were 3 express references to what the first tier had found. It might not be the way your lordships would have approached it, but as the case law makes clear, there is no single right route. Ultimately, it considered the facts it considered to be relevant.
Are we looking at 109110 at the moment?
109, no, I'm looking at the full 2 pages of...
The full 2 pages, but is that not vulnerable to the same point as we were discussing before, which is it has a heavy, if not exclusive, focus on the fact that Miss Adams' other activities have been conducted in a freelance fashion?
I would say that's not a failing.
No, the question is not... the criticism there is not that I've accepted, for the sake of argument,
yes,
that it would be not right to decontextualise, accepting that for the sake of argument. The opposite criticism appears to be being made of these parts of the reasoning by the revenue, and that is that it's looking only at the context and not looking properly at the where the focus really ought to lie, which is primarily on the terms of the agreement. And so what do we find in this treatment, either by reference, because of course they don't have to set things out, they can say, yes, well, in paragraph X, absolutely, the FTT said this and we think so too, or whatever it is. Where do we find that? Well,
as I submitted this morning, what are the key terms of the agreement? And they're in paragraph 114. I respectfully submit that there is the wider contractual terms, such as Ofcom compliance, confidentiality, disrepute, etc. They are not that relevant in this kind of exercise. So what are the key things that a fact-finding tribunal, or a decision-making tribunal, needs to consider? It's ultimately what was provided in what context. There was nothing jumping out on the contractual analysis, or wider factual analysis.
And in these passages, there's specific reference to back up what is being said. 110 of the FTT, 111.2, 112, 113 are all referenced.
Yeah. When you say, you're asking whether they are...
Yes, well, I'm noting
yes,
that although they are drawing attention to those parts of the FTT.
All part of the consideration that it is undertaken.
So you made the submission that in 114 the UT considers all the key terms, as you would have it, of the contract. Mm-hmm. But let's just test that by reference to a term that featured very largely in the other case that we heard, which we also find in this case, which is the first call.
Yes.
So on your submission, the first call obligation has to be irrelevant because it's not mentioned.
It is mentioned. I would say it's the penultimate line of 114. Ms. Adams would have been obliged to present at least 160.
No. 8.1 of the standard term says, during the term, the BBC will have first call on the freelance services of the contributor, subject only to any prior professional commitments of the contributor which have been confirmed to the BB representative in writing prior to signature hereof. So would you accept that that term is relevant to put into the mix?
Yes, to the extent that it hasn't already been relevant in the application of the control text, because they certainly considered it at the control point.
Indeed, but where is it put into the mix in this part of
I
the
would
analysis?
submit that it's implicit in the words would have been obliged to present at least.
But that's in Part A of the contract. Minimum commitment is 160 programmes.
Yes, but that has to be read. Clause 1.8.1.
And what about clause 8.2? During the term, the contributor will not, without prior written consent, be ceased, not to be unreasonably held, hear any other third-party audio and/or visual content, primarily intended for audiences in the UK.
I would submit that is standard provision that anyone wanting to ensure there's no conflict of interest.
So you're saying it's irrelevant?
It's certainly not relevant in the. It's of very little weight in a question in a case of is this person employed or self-employed.
Very little weight. So you don't say it's completely irrelevant.
I say all facts are potentially relevant, and it's for the.
So where is it analysed?
No, it's not. It's not there. But in the same way, nor the other facts that the Upper Tribunal accepted were of little weight, such as the lack of statutory rights, etc. The whole framework, the fact that it says freelance, these are all matters that are considered to be of little weight, but not completely irrelevant. But the Upper Tribunal considered them to be insufficient to pull something back. My Lord, you're probably aware of paragraph 63 of the Upper Tribunal's decision, which shows that the Upper Tribunal was perfectly conscious of the terms at 8.2, etc. It's not as if the Tribunal was blind to those terms, because it actually had to make detailed consideration when reworking the hypothetical contract. Well, first, certainly what the actual contract was, and then reworking the hypothetical. I was submitted. Sorry, no.
I'm sorry, so you were about to.
I'm just going to say it's unrealistic to focus on a 2 pages, and I agree they're densely written, but to forget that the Upper Tribunal had, in the same decision, only 10 pages earlier or so, reached certain findings of fact, to think that it had then just simply cast them aside when reaching its decision.
So really you say we ought to read the decision as a whole.
Absolutely.
And bear firmly in mind that 2 specialist tribunals have reached the same findings, although by varying reasonings.
Yeah. I would submit that
Same conclusions,
it
actually.
was the same conclusion for ultimately the same reason on different hypothetical contracts. One was more adverse to my client than the first. But the clear point that is driving this case and others of, such as Kickabout and others, which you've seen Chris Rackwood, there are others floating around the system, is that for individuals who are running a wider self-employment, that is the main clinching fact. Chris Ackroyd is in many ways the exception because she didn't have any other strings to her bow.
So that leads to the submission that we have to consider under ground one whether there was an error of approach, and if we consider that there was, whether it actually affected the way in which the decision came to be made, or whether it was simply a misstatement that didn't have those consequences. But that moving in any event onto the second stage, you say these are specialist tribunals who have shown that they know what the evidence contains and that we shouldn't trip up the Upper Tribunal for not putting it in a different way.
Indeed. It's a specialist tribunal. Obviously, it's a specialist tribunal in the tax context. And employment status is clearly Janet and John stuff in the employment tribunal, but this is bread and butter in the first tier as well, first tier tax shape up. So one should respect the specialist tribunal to be able to get employment status, correct?
Right, so where you would come off the rails is if we considered that there was an error of law which did infect the decision-making process. At that point, it becomes very hard.
Absolutely. But if you were to do so, I would say with respect, you'd be revolutionising the law of employment. You'd be taking it, moving it off the path it has followed pretty steadily for 54 years.
Well, that's clear. I don't mean to agree with you. Your submission is clear. Yes. Yes. All right. That's ground two.
Unless your lordships have any further questions on ground two.
No, thank you.
In that case, as I then move on to our other reasons, perhaps this will be clearly obvious, but I just want to sort of build up the speed. The court will be aware of the three stages relevant in a IR35 case, rather than the three stages already in its concrete case. The three stages of IR35 are set out in paragraph 6 of the Upper Tribunal's decision. Find the actual contract. Move on to determine the hypothetical, which isn't necessarily straightforward transposition. And thirdly, then analysing, categorising that as employment or self-employment. Stage one requires a determination of the actual terms. This is an exercise of fact-finding. And one of the disputes in this case is the mismatch between, on the one hand, the written agreement between Atholl House and the BBC, and on the other, the understanding of Ms. Adams and the BBC employees as to what was contractually agreed.
We say as to what was contractually agreed. You're not suggesting, first of all, that this written contract wasn't entered into.
No.
Nor are you suggesting that there was any express oral agreement varying the terms of the written contract, even if that could stand in the light of the entire agreement clause.
Exactly. When I'm just saying that if you asked the individuals who gave evidence, whether it's HMRC's evidence witness or Atholl House's evidence witness statement, if you ask them, what do you think the contract is? There is a mismatch between that and what the written
But their
terms.
subjective understanding
Indeed, no,
is irrelevant.
I'm not disputing. I'm just wanting to set the facts. So it would be a classic case of a subjective understanding is not sufficient. Do the written terms prevail?
Just so I can understand this,
Yes, of course.
I'm sure my lords do already, but are we now on your different grounds? Yes, I mean, is it helpful for us to have 43 of the bundle, which is where you set this out in
The core bundle.
in your respondent's notice. Yes, I have it at page 43 at paragraph 3 and onwards. Right. Right. So can you just situate us in this document?
What we are saying is that in the first tier, the tribunal considered applying autoclaims that the written terms were not actually the true.
That's the mismatch.
That's the mismatch, right. And the first-tier tribunal, applying autoclaims, remedied the mismatch by not following written terms, but by actually determining what was the true agreement, a finding of fact. And in due course, I'll make it clear in my submission that the first tier was right to do that and did it correctly. On HMRC's appeal to the Upper Tribunal, their argument that autoclaims was not correctly applied or was wrong to be applied was upheld, which led to the Upper Tribunal remaking the decision and remaking those findings of fact, in other words, the actual contracts, which are then fed into the hypothetical contract. So all the submissions that have been made by both parties up to now have been based upon the Upper Tribunal's findings of fact. However, we say that there was no error of law in the first tier's approach. Therefore, the Upper Tribunal was wrong to intervene. And therefore, on any proper analysis, it's the first tier's contract, which is much less onerous on Ms. Adams, is the one which should be considered. We say the first tier's approach is entirely consistent with the case law that predated autoclaims itself, and the subsequent case law developments, including, most notably, Uber and PG Mob. So what I propose to do is to consider the autoclaims approach. I can feel the authorities will not take as long as this morning's, to show how the first tier faithfully applied the autoclaims approach, and therefore show why the Upper Tribunal was wrong to set aside the first tier's decision. As far as the pre-autoclaims authorities, I've already made very brief reference to it in Leading Sang. Don't necessarily need to take your lordships to it. It's page 227, 384F of the report.
So it says volume 1, page
227.
227.
There's a similar passing reference to the decision, the speeches in Carmichael, the House of Lords. I could ask your lordships to turn to the Lord Chancellor's speech, page 283 of the bundle. This deals with questions of whether or not they are questions of fact or questions of law. I just want to rely upon the first couple of lines for a moment of that page, where if this appeal turned exclusively, and in my judgment it does not, on the true meaning and effect of the documentation, there's already a hint in Lord Irvin's speech that the written terms aren't necessarily determinative. But we see between B and C, in my judgment, it would only be appropriate to determine that issue in these cases solely by reference to the documents in 1989 if it appeared from their own terms and or from what the parties said or did or subsequently that they intended them to constitute an exclusive memorial of their relationship. The industrial tribunal must be taken to have decided that they were not so intended, but constituted one, albeit important, relevant source of material from which they were entitled to infer the parties' true intentions, along with the other objective inferences which could reasonably be drawn from what the parties said and did in March 1989 and consequently. So we already have the genesis of a suggestion that the written terms do not prevail in certain cases. And if I then can ask your lordships to turn a couple of pages to 285 of the bundle, where we have the speech of Lord Hoffman. And just below A, the new paragraph, it was this rule upon which the majority of the Court of Appeal relied on as entitling to the construction of the exchange of letters. Jumping to between B and C, I think the Court of Appeal pushed the rule about construction of documents too far. It applies in cases which the parties intend all the terms of the contract to be contained in a document or documents. On the other hand, it does not apply where the intention of the parties objectively ascertained, I emphasise, has to be gathered partly from documents, but also from oral exchanges and conduct. In latter cases, the terms of the contract are a question of fact, and of course the question of whether the parties intended documents or documents to be an exclusive record of terms is also a question of fact. Now, I wouldn't necessarily rest my case on those two speeches, parts of those speeches, but I then turn to autoclens itself, which is page 437.
Four what?
437
437.
437, my lord. And I'd just like to highlight first the headnote and what was held, just to give a summary as to what autoclens was formally concluded. In cases of contracts concerning work and services, the question the court had to answer in every case was, what contractual terms did the parties actually agree? The court had to decide whether or not the words of the written contract represented the true intentions or expectations of the parties, and therefore their implied agreement and contractual obligations, not only at the inception of the contract, but at any later stage where the evidence showed the parties had expressly or impliedly varied the agreement between them. While employment was a matter of contract, the factual matrix in which the contract was cast was not ordinarily the same as that of an arm's-length commercial contract. The relative bargaining power of the parties had to be taken into account in deciding whether the terms of any written agreement truly represented what had been agreed, and the true agreement would often have to be gleaned from all the circumstances of the case, of which the written agreement was only a part. What the Supreme Court has made clear in autoclens is that we have a fundamental departure from the basic tenets of contract law. And we see that particularly clearly in paragraph 20 onwards in the judgment. If I could ask your lordship to turn to page 445. Actually, 444 is where it starts. And what paragraph 20 does is summarises what will be well understood authority as to contract law, as it has been for many, many years. In other words, subject to very limited exceptions, if parties have signed an agreement expressing their contractual relationship between them, those written terms will prevail. I'm not in any way seeking to diminish that fundamental principle. But what paragraph 21 then goes to say is, but those rules are not applied in the world of work. Nothing in this judgment is intended in any way to alter those principles which apply to ordinary contracts, and in particular to commercial contracts. There is, however, a body of case law in the context of employment contracts, and I use employment in the broadest sense, in which a different approach has been taken. And again, there's reference made to the Court of Appeal, Lord Justice Aikens, in the remainder of the paragraph cited. In cases of contracts concerning work and services.
Yes, we can read what's
Right.
But how, I mean, I can see, obviously, in relating to car valeting, how this may be relevant, but how does it relate to the present case?
This was a case where the first tier held, well, first of all, this is a contract within the terms of work and services.
Yes, all right, but there's a world of difference between what the auto cleanse situation and the situation that arises in this case. There's no, at least that I'm aware of, any suggestion of inequality of bargaining position.
Indeed. What I say is that the inequality of bargaining position is a matter that has to be taken into account. It is not a precondition. That's my submission.
It goes further than that.
There wasn't any. I'm sorry.
I beg your pardon. Did you finish?
But it doesn't. There isn't any inequality of bargaining position in this case.
None on the finding of fact, no.
No, nor could one even imagine that there could have been. It was a peculiarly balanced situation for the parties.
I would say there's a practical imbalance in that, as a matter of practicality, not necessarily with hindsight wisdom, but in practice, someone says, oh, we've got the contract, you just sign the terms. One side clearly has a legal body which can draft the contract.
Well, for perfectly good reasons, your client decided, or Miss Adams decided not to have an agent, not to have go through it with a tooth comb. She trusted the situation that previously existed. Anyhow, there are no findings, so don't spend your time on that. But I understand that in employment circumstances, there may be reasons why the strict rules of contractual construction are somewhat modified.
Indeed.
But what's that got to do with this case?
Because when one looks at what the Supreme Court said, it did not put down any preconditions as to when you depart from the written terms.
Right, so because in some cases there can be inequality of bargaining, and often no doubt there is, it applies in all cases.
And in all cases, what involving work or services, what has to be determined is the true agreement between the parties.
Yeah, but that's in a situation where one side is saying the paperwork doesn't represent the reality. Whereas your client's case was the opposite. Your client's case was, on its face, this is a freelance contract, and that's the reality. So your client's case was that the paperwork perfectly matched what she said the reality was.
Our case is that there were aspects of the contract which state what we're saying, but the precise terms and the obligations didn't match the
But
reality.
that's a rectification case.
My Lord, no, it's not necessarily rectification. And
You're seeking to persuade us that the FTT was entitled to come to its conclusion on the first call provision and on the other provision in question by applying auto claims.
Indeed.
So I think it might be helpful if you've shown us the very basic statement, and it's a quite different jurisdiction from rectification.
Absolutely.
And so I think what might be helpful is if you were to show us how the Supreme Court in auto claims explained how this was to be done, because I don't think they just leave it with that statement.
They certainly don't leave it, but
I think it's important to understand how they say a court is to go about doing it, and then we shall see how the FTT went about doing it and the way in which the UT said they were wrong.
indeed. I'm grateful, my Lord.
Yes.
So I think I got to the true agreement of the parties alongside G. Cases of contract, if they do not, rectification principles are not in point. There may be several reasons, so I emphasise that there's no single magic bullet. why the written terms do not accurately reflect what they agreed, but in each case, the question the court has to answer is, what contractual terms did the parties actually agree?
Yes.
And I will go through between paragraph 21 and paragraph 35 of the Lordship's judgment. But we keep on getting to the same test. In each case, the question the court has to answer is, what was actually agreed? And I can't run away from the fact that the cases...
Take us through auto
Okay.
Correct. Because time is short. It's absolutely critical.
Paragraph 22, it talks about the Employment Tribunal adopting a test that focuses on the reality of the situation. But then at paragraph 23 highlights that there is a historical context, which includes Snook, which one just has to bear in mind. There was a dispute between Mr. Justice Elias, as he then was, in a case called Kalawak, and the Court of Appeal. And
where are you reading?
I'm between around about 27.
Right. It's helpful to know where you
Yes, I'm just moving my way through, just explaining a sort of little debate.
I'm really anxious to see how Lord Clark says this jurisdiction is to be exercised.
Yes.
Sure, he doesn't leave it as vague. He may do, but as vague as what is the real agreement.
Well, coming
it's not as if the written terms are irrelevant to this.
Paragraph 29 is the next bit. I just wanted to give you the background.
Right. Yes.
So the question for the court is not whether the two approaches which have previously been debated are consistent, but what is the correct principle. I unhesitatingly prefer the approach of Elias J. in Kalawak and of the Court of Appeal in Silagi, and in this case to the Court of Appeal, to that of the Court of Appeal in Kalawak. The question in every case is, and it repeats this simple mantra, what was the true agreement between the parties? And then there's reference to what Lady Justice Smith had said, and that's a judgment you've already been taken to by my learned friend in a different context. The kernel, so in paragraph 30 if that helps, the kernel of all these dicta is that the Court or Tribunal has to consider whether or not the words of the written contract represent the true intentions or expectations of the parties, not only at the inception of the contract, but if appropriate as time goes by. Then Lady Justice Smith clarifies a potential misunderstanding over the next page. What I wish to say, and these are all endorsed now by Lord Clark, what I wish to say was that the Court or Tribunal must consider whether or not the words of the written agreement represent the true intentions, and therefore the implied agreement and contractual obligations, not only at the inception, but at a later stage where the evidence shows the parties may have expressly or impliedly varied the agreement between them. In my judgment, the true position, consistent with Tanton, Kalawak, and Silagi, is that where the dispute is the genuineness of a written term, the focus of the inquiry must be to discover the actual legal obligations of the parties. To carry out that exercise, maybe this is what Sir David Richards was asking for, the Tribunal will have to examine all the relevant evidence. That will, of course, include the written term itself, read in the context of the whole agreement. It will also include evidence as to how the parties conduct themselves in practice, what their expectations of each other were. Evidence of how the parties conducted themselves in practice may be so persuasive that the Tribunal can draw an inference that the practice reflects the true obligations between the parties. But the mere fact that the parties conduct themselves in a particular way does not itself mean that the conduct accurately reflects the legal obligations. I'm not going to say, and this is the point Lord Justice Arnold made, I'm not going to say that intentions and beliefs, subjective beliefs, are determinative. But nevertheless, and that's just an example there. If I may continue, we have reference to Lord Justice Aikins in the case, and halfway through that paragraph, just below little h. But ultimately, what matters is only what was agreed. Either as set out in the written... Sorry, alongside little h on that same page, 448 of the authorities. So this is the... But ultimately, what matters is only what was agreed, either as set out in the written term, or if it is alleged those terms are not accurate, what is proved to be their actual agreement at the time the contract was concluded. I accept, of course, that the agreement may not be expressed, it may be implied, but the court or tribunal's task is still to ascertain what was agreed. And then to that, Lord Clark says, I agree. And then there's reference to what Lord Justice Sedley had said, recognising it does that while employment is a matter of contract, the factual matrix in which the contract is cast is not ordinarily the same as that of an arm's length commercial contract. So in other words, everything that one has learned in contract law can more or less be put to one side because there is a different exercise being conducted. We have further reference to the Court of Appeal, and then finally at paragraph 5, actually I will cite paragraph 34. I respectfully agree with the view emphasised by both.
We see what's there.
Yes.
And it all ends up at 35.
It all ends up at 35. But if I could just go from what Lord Justice Aiken said very quickly. Contracts are often, contracts of employment are often entered into between people of different bargaining power. And at 35, Lord Clark makes it very clear that the relative bargaining power of the parties must be taken into account when considering whether the terms of any written agreement in truth represent what was agreed, and the true agreement will often have to be gleaned from all the circumstances of the case, of which the written agreement is only a part. This may be described as a purposive approach to the problem. If so, I'm content with that description. What the first tier did was, in light of that guidance, determined what was truly agreed by taking into account all the evidence, all the arguments, all the facts surrounding the intent of the contract. Now, what I do want to emphasise is the cases of which auto claims was a clear example. Those are all ones where there was clear and extreme imbalance, and I'm not going to shy away from that. But what I say is that there is nothing in any of that judgment or anything that's followed that suggests that imbalance of bargaining power is a precondition. And I would suggest that to put that as a precondition would actually water down the effect of auto claims, because it puts the employment tribunal having to go through an extra preliminary test.
Yes, I mean, it's not what Lord Clark says. He says it, but he does say it must be taken into account.
Absolutely.
Yeah. I mean, you could well envisage a case in which HMRC would be saying that provisions have been included in the contract to make it look like a contract for services. But the actual agreement of the parties indicated that they were just they were not intended to take effect in accordance with their terms.
And
analogously with the provisions about the valeteers in this case.
Indeed, we actually have an example of this very case, because what the first tier did was notice that the written terms included a substitution clause, possibly designed to ensure that it was not an employment contract or quasi-employment contract. The first tier, in its analysis, erased that. But, yes, there's nothing.
All right, so you have to have regard to the relative bargaining power, but it's not stated by Lord Clark to be determinative or a precondition. He did say, he approved what Lord Justice Sedley said.
Indeed.
That the elaborate, this is in paragraph 104 of what Lord Justice Sedley's judgment. And he says the elaborate protestations in the contractual documents that the men were self-employed were odd in themselves, and when examined, bore no practical relation to the reality of the relationship.
I'm not going to shy away from the fact that this body of law was based upon extreme cases, almost where workers were being abused. But that's not the precondition. It's those extreme cases that are given rise to the legal rule of law, and we say that that has to be applied in all circumstances. And the phrase is mentioned a number of times, the paramount question is, what is the actual agreement?
Right. Do we want to go to the FTT now to see what they...
I was going to just go say that Uber, nothing in Uber changes it.
Right.
Is that right? I haven't studied Uber, but Lord Legate is concerned to understand the sort of the basis of this jurisdiction and approach. And he says that the Supreme Court did not spell it out in auto claims. And he suggests that this is actually, these are actually principles of statutory construction, not contractual construction. And that it is actually looking at at the statutes that are conferring relevant rights on the workers or whatever it is, that's the underpinning. I mean,
yes, and that's why I wanted to address Uber before going straight to the first tier.
All right.
Yeah.
Because if one reads what the auto claims principle is, as stated in Uber, nothing changes it. There is the question as to, has Lord Legate then somehow said, well, it all boils down to, are certain statutory rights engaged? But the problem we have is that if it's purely a case of statutory interpretation, then we find ourselves with a mismatch in a case like this, where we have to determine a question of common law. Is this an employment contract or not?
well, that all depends on what the Supreme Court said in Uber, whether there's a mismatch.
And it didn't suggest there was... I would respectfully explain the Lord Legate's approach as what ultimately is the question that needs to be addressed. Are these workers entitled to certain statutory rights?
Yeah.
And he was able to do that without getting too bogged down in the application of Uber and dealing with Lord Justice Underhill's powerful dissent in the Court of Appeal. So I would say it was almost a shortcut, but it doesn't actually...
Well, you better take us to what Lord Legate said, with whom all the other members of the court.
Oh, of course, yes. I would say the relevant section starts at paragraph 68, so it's page 1028. I'm particularly relying on the first half of paragraph 68, which I would suggest summarises far more eloquently than what I've spent the previous 10 minutes trying to distill from auto claims up to entitled to do. I won't read it out.
So where should we read down to?
I'm just entitled to do halfway through that paragraph before we start looking at the philosophical justification.
Well, but how can we stop there when he goes on at 69 to say critical to understanding the auto claims case, as I see it, is the rights asserted by the claimants were not contractual rights but created by legislation?
That, my lord, that's simply saying that what was the ultimate question for the court to decide was whether these drivers were entitled to certain rights, statutory rights. So they were not in itself rights in any form of contract. They were freestanding rights governed by statute. Rather than examine the question and rather than categorizing the contract, it didn't need to categorize a contract. Was this a contract of employment, which it wasn't? Was it a workers' contract? Was it a freelance non-workers' contract outside Limb B? What Lord Legate did was said, actually, we can just tick the boxes of the statute and ask the questions that the statute is asking us to the facts of this case. So it didn't actually have to then do that intermediate stage of categorizing the contract. what had been argued below was this is a contract, this is a Lim B worker because X, and as we're a Lim B worker, we're entitled to these rights. Lord Legate short-circuited that process. So, but that explains, but it doesn't in any way suggest that the common law question can or should be answered any differently. Otherwise, you're going to get a mismatch.
Well, indeed, but I mean, the opening sentence of 68 is where one has to focus on. The judgment of this court in auto claims made it clear that whether a contract is a, quote, workers' contract within the meaning of the legislation designed to protect employees and other workers is not to be determined by applying ordinary principles of contract law, blah, 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 etc. Not only was this expressly stated, but had ordinary principles of contract law been applied, there would have been no warrant, etc. So, I mean, he is positing the exercise of the jurisdiction as being in the context of applying a statutory definition, which is why I think that at the end of 69, he says, in short, the primary question was one of statutory interpretation, not contractual interpretation. Now, true it is that in determining for the purposes of the statute whether certain rights are conferred on the worker, the contract will be maybe interpreted in a way which was different from applying the common law rules. But he doesn't here say that, as it were, because this is what you do when you interpret a contract in this statutory context, therefore you must do the same thing when it's simply a common law question.
My Lord, we've got to remember that there is no common law equivalent of worker. That is a purely statutory
Correct.
construct.
Correct.
And when I say worker, I'm saying Lim B because it's easy, the Lim B worker rather than the
Yes. wider
definition of worker. Therefore, it's absolutely correct that one doesn't have to go through the process of categorizing a contract in order to decide whether the Lim B rights are engaged. But for Lim A, and also the question that this court has to grapple with, albeit in a statutory context, the question is a common law question.
Yes.
And I would suggest that it would be, first, bizarre, secondly, inconsistent with everything that was actually said by Lord Clark, for that question to be dealt with without applying the auto-cleanse approach. For example, if a contract purported to say something so as to deny someone the status of employee, and therefore deny someone entitlement to statutory claim for unfair dismissal, that's a right that a Lim B worker isn't entitled to. A court or employment tribunal will have to decide whether that person is entitled to make a claim for unfair dismissal, and that turns on whether they are engaged, I can't remember the precise wording of section 230, but it's something along the lines under a contract of employment. Boils down, more or less, to the common law question. And I would suggest that it would be extremely odd if the rights and liberty given by Supreme Court in auto claims, which means that people who are and should be truly employees, if one takes the reality of the situation, suddenly find that they are bound by the written terms when they don't reflect the true agreement between the parties. So, yes, the context of auto claims and UBO in particular concern Lim B rights. The principles are expressed more widely and cannot. It would be a retrograde step if this court was to suggest that it applies only in the context of workers and to work out whether you're within Lim A or not. You're bound by old-fashioned case law such as Strange and Grubhub.
my understanding, and correct me if I'm wrong, is that the reason why it was a 7-member panel of the Supreme Court in this case was that the correctness of auto-cleanse was one of the issues before them.
Indeed, because Lord just, well, I can't remember quite to what extent the correctness, but there was certainly the extent of auto-cleanse was considered, because as I said, it was a very powerful dissenting judgment from Lord Justice Underhill, because this was a context where you had multiple parties. You had the passenger, Uber, and the drivers. And Uber, I think there were two different entities within Uber itself. But what we have is a sensible approach, not getting bogged down to, well, the fact that this contract was with a passenger, therefore doesn't come within the work environment. The context was provision of work and services.
Well, the question is, and we have your submissions, that whether paragraph 68 and 69 confine the effect of auto-cleanse
to the worker situation.
Well, not necessarily to, maybe not necessarily, but that's not been explored. But
to a statutory situation?
Exactly. I mean, put it absolutely broad.
Well, I'd submit, no, it can't for the reasons I've already advanced.
You say it creates a mystery.
For
example, it could. So, in other words, well, I suppose it would be this, would it? That in determining whether a putative employee enjoyed statutory employment rights, then the court would apply auto-claims.
Indeed.
If it were concerned with other questions, for example, the validity of a restrictive covenant or something like that, then it would apply common law principles.
My lord, no, I would suggest that...
Because after all, the clauses we're concerned with here, I mean, there is no relevant statutory restriction, is there?
Except we are within a statutory context. In this case, we're looking at...
No, I think that it arises under tax legislation, but as you said in your very first submission, there's nothing special there.
Yes.
It's just the common law rule.
Indeed.
Yes.
I would submit that if a worker, and this is clearly a hypothetical situation, but if Mr. Belcher from AutoCleanse were being held to a restrictive covenant, I would say that the validity of that, if it didn't reflect the true agreement, would be subject to the same AutoCleanse approach. It's not focused on a set of statutory rights. It's trying to determine the true agreement, and the true agreement is the true agreement for all purposes.
All right. Well, I won't take. I mean, fine. It's 3 o'clock, so you're very short of time. I'm sorry. So what you see, the Upper Tribunal's criticism of the FTT was that they hadn't explained why they applied auto-claims.
So which?
Isn't that in this case, the Upper Tribunal said, well, we don't really understand. They haven't explained why.
Yes.
They applied auto-claims. Isn't that right?
They did, and it's for the reasons it gave. We say deficient for the reasons set out in the assignment.
Yes, I see.
But what I was going to do is just take you to what the first.
Yes, I was going to say that. See how they put it. That seems to be really important. Really.
Yes. And
Right, so where do you want us to go first?
first, core bundle, page 142.
Thank you.
Where we have because it was a live issue very much in the First-tier Tribunal. So unlike all lower point, it was centre stage.
Right. Well, could we, as it were, cut to the decisive parts?
Yeah. There was a full citation of what Lord Clark said. So
Yes, a
actually
very full citation.
Yes.
I see that.
Then there's a summary at paragraph 27, page 146 of the bundle,
Yes.
of the principles. So that's the succinct version.
Yes. 28. It's possible that something that's not a sham still doesn't form part of the actual agreement.
So I'm on 27.
But I'm being even more rushing you than my lord, because we've got the law.
Yes.
We don't need to see the FTT's analysis of the law. We want to see how they applied it.
No, this is what I'm saying. This is the. That's why I've skipped over.
Yes, let's see how they applied autoclaves to the facts of this case.
It then made various findings of fact over a large number of pages, and then at paragraph 91.
Paragraph 91.
So there's an awful lot of fact finding before it starts applying the law. Paragraph, so it's page 173 if that helps. It reminded itself of the correct legal principles. Then at paragraph 92, it expressly recognised the tension between the evidence it had heard and the written terms, and in particular, the provision that purported to be an entire agreement provision. So it was fully on board with this question. And at paragraph 93, it then set out its conclusion, why the true agreement was different from that set out in writing. It's worth emphasising that Mr. Patterson was HMRC's witness. The First-tier Tribunal also had notes of meeting between HMRC and the BBC. If I remember correctly, both versions, one was noted up by the BBC, one noted up by HMRC. At that meeting, BBC had their legal representative there who didn't dissent from any of the assertions as to what was going on, and she didn't say, well, actually, we could pull rank. So the first tier had a full range of information, allowing it to reach the conclusion that the true agreement was different from the written terms.
Right. In respect of 93 and 95, those are the different.
Indeed. Some in my client's favour, some against, or one against. We say that that was entirely in line with the autoclones approach, now confirmed by Uber, and absent any error of law.
Can I ask you about this? Because one of the things that puzzles me about all of this is what the basis for it is. So if you go back, for example, on this question of first call,
Indeed.
The finding appears to be actually in 87, where they say the evidence of both Ms. Adams and Mr. Patterson was to the fact that the BBC simply did not have the right of first call on Ms. Adams' time or the right to control Ms. Adams' other engagements.
Yes.
And then they refer back to the evidence that they received. And so far as Mr. Patterson is concerned, that's 58E, which is at page 164. Mm-hmm. Now, at the moment, I'm struggling to see where in that subparagraph he is recorded as having said that the BBC simply did not have the right of first call.
He confirmed that Ms. Adams did not ask anyone at the BBC for permission to take on any other engagements.
Which is, of course, not the same thing.
Other than the fact that if that precluded Ms. Adams appearing on a particular day.
The fact that someone was in breach of an agreement doesn't show that the agreement didn't exist.
My lord, but what we're allowed to take into account is how the parties conducted themselves to try to, as evidence.
All right, but can you answer my question? Have I missed it? Is there some part of subparagraph E where the witness said, as he's claimed to have said, the BBC did not have the right of first call?
The last sentence makes it clear that if he had been aware of any requirement to ask anyone else for permission. So the words first call aren't there, but I would again repeat the submission I made earlier today, that it's implicit.
But we know we need to distinguish between what the contractual rights
Yes.
are and what happens in practice, because a contractual right may not be insisted upon. But the fact that contractual right isn't insisted upon doesn't mean to say it doesn't exist. So where does he say the BBC simply did not have the right of first call? If the correct answer is it ain't there, then you can say so.
What I'm also looking at is 57L and P, which is
That's
also,
her evidence.
Indeed. But
I'm looking at his evidence, because
But I'm not
the suggestion is that it's supported by Mr. Patterson's evidence.
the evidence of both, it's a distillation of the evidence of both parties, or both witnesses.
What they say in 87 is that the evidence of both Ms. Adams and Mr. Patterson was
To
the
the
BBC
effect.
simply didn't have the right of first call. Well,
And I will submit that if there are no restrictions on her work, which we see in 57L, and similar wording in 58E, that amounts to overriding first call. You can't have first call if you, other work is allowed to predominate or allowed to take precedence.
I don't think, sorry, it's L, isn't it?
L
so
for Lima.
In her evidence.
My lord.
Right, so whether they're accepting both of their evidences or her evidence with which his evidence wasn't inconsistent.
I would say that the combination of the two amounts to saying the first call was a fallacy.
So that's, anyway, so we see there, that's the basis of the F87 is really the linchpin, isn't it, as sort of added to by 88 and 89, but that's really the linchpin of the FTT's decision.
As far as first call is concerned, yes.
Sorry?
As far as
first call is concerned, yes.
And control generally.
And control generally,
Yes.
yes. Right, so what did the Upper Tribunal say about that reasoning?
The Upper Tribunal's criticisms start at paragraph 44, so it's core bundle, page 91. And at 45, the Upper Tribunal puts forward the proposition that the written terms were meant to contain the entire agreement. Now, there are two interpretations to what the Upper Tribunal has done. Either they put the cart before the horse, or they explain, they're coming up with their conclusion and then explaining the reasonings in the following paragraph. If it's the cart before the horse, then that's clearly an error of law. I'm working on the presumption that it's explaining the reasons that follow. Paragraph 46, the Upper Tribunal identified three factors that the first tier relied on to reach its own conclusion, which are essentially those paragraphs 87 to 90 of the first tier's decision. At 47, the Upper Tribunal asserted that these factors were not normally ones that could justify displacing an entire agreement provision. Now, I submit at that point it's not even clear whether...
Sorry, where are you?
I'm at 47.
47. So, just looking at 46.1, I mean, they read, I think, they read paragraph 87 as I think my laws were, as being based, or as it appears, being based on what was said in 57 and 58, was it?
Indeed.
Yes. So there's not other evidence that it isn't referred to in the FTT decision. It's that evidence. Yes. Which is all, yes, I see. Yeah, okay.
47, the assertion is made by the Upper Tribunal that the factors relied upon are not normally ones that could justify displacing an entire agreement or provision. But I submit that the Upper Tribunal is already forgetting the autoclaims approach that needs to be followed. But it does then continue to say, well, there's no reason, so it doesn't really matter. Things that we suggest go completely wrong at paragraph 48. Where we see the Upper Tribunal in our submission wrongly conflating the ordinary principles of contract law to the special regime that operates in the world of work. And if I could just highlight paragraph 40 on page 86 of the bundle, where I submit is the basis of that misdirection. Paragraph is effectively, it's still looking at the non-auto claims rules of contracts.
Yes.
And we then come to the critical passage at 49, where the Upper Tribunal sets out what it considers to be reasons why the first tier failed to apply autoclaims properly. We have the opening words of 49, which are introductory. But in response to that, we simply say that the first tier took a holistic view of the evidence and did explain its reasons and did so carefully. Moving swiftly on to 49.1, if I can just rely upon the first 3 and a bit lines. The written agreement was indeed a standard form contract. In our respondent's notice, we inferred that the Upper Tribunal was criticising the first tier for having put too much weight on the fact that the written agreement was in standard form. As our skeleton points out, the first tier made no such point, so it's a if that is part of the criticism of the first tier's decision, then it's just a non-point.
So that doesn't appear in the FTT decision.
And so far, obviously, I have to wait for what the defence says, but my defence submissions do not address that particular point at all. The Upper Tribunal then continued. There was no obvious imbalance, but I've already responded to that. The autoclaims does not impose a threshold before written terms may be displaced, and therefore, what we inferred from the Upper Tribunal, it was imposing a condition that doesn't need to be overcome. It appears from my learned offence skeleton argument, the supplementary skeleton, that they agree with us on the principle that there isn't such a hurdle, but they point out that the Upper Tribunal was entitled, even obliged, to take any imbalance of power into account. And I would submit that obviously right, that if the Upper Tribunal is remaking the decision on autoclaims, it has to take into account balancing things. But I submit that it shouldn't even have been in the realm of remaking the decision, because so far it hasn't yet found an error in the first tier's decision. So this is one of those cases where a new finding has been made by an appellate body when it hasn't actually found the required prerequisite error of law from below.
Is 49.2 on your submission anything other than a disagreement with the fact-finding of the First-tier Tribunal?
What we say with 2, 3, and 4 is that that the Upper Tribunal has imposed a test of realism.
But in the result, is it doing anything more than saying, well,
the
FTT may have thought that, but we think this?
Yes, without having heard the evidence and without even being in a position that it could remake the decision.
Well, it's saying the FTT did not conclude the right of first call was unrealistic. Now, they're noting this because, I think when we were going through auto claims, there was reference to I think Lord Justice Sedley said these were very odd provisions and so on. They're just noting that the FTT hasn't said these are very odd provisions. Isn't that all they're doing here?
Well, if that's all they're
It's not
doing,
saying this isn't a ground for upsetting the FTT decision, but it's saying, well, it can't be supported on that basis.
but the opening of
But the
paragraph,
FTT didn't seek to support it on that basis.
the opening of paragraph 49 says
Particularly we
these
don't.
are the reasons why there's
Whatever, but I'm not. Yes, I mean, it may be they're cumulative rather than to be taken seriously.
But what we're saying is it's all very well being
Well,
communicated.
you don't disagree. I mean, the FTT didn't find it to be unrealistic.
But again, we say that that is not a condition that needs to be overcome.
Absolutely, I understand.
And that dispenses with 2, 3, and 4. Because what the Upper Tribunal has done is effectively gone back to pre-auto-cleanse approaches to contract.
Yes.
We see
It
this.
seems to me that it's really paragraph 87 of the FTT's decision, which is the absolutely critical. Because after all, their conclusion is that both Ms. Adams and the BBC agreement was actually to the contrary of the written agreement. But that itself is based on the summary of evidence in paragraphs
57, 58.
And
And also the...
as my Lord has said, raised, is that evidence sufficient to support the conclusion that the FTT came to?
This is one of those typical cases where a fact-finding tribunal hears the evidence, cannot
But
repeat.
we don't have a finding that at the time the contract was made, they believed that there were no such provisions.
I believe that Ms. Adams would have given oral evidence to that effect based upon her previous dealings and when a new contract came on board.
It's not summarised.
It's not summarised, but it doesn't mean that the first tier hasn't considered it, because it's heard all the evidence.
I mean, if that was her evidence, it's very surprising they don't recite it, because it absolutely goes to the heart.
Well, I would submit that 57, it doesn't. It's not a time-bound statement, but it applies as much before the contracts were entered into as afterwards.
But is it?
I would
Is
submit
it
it is because
really 57, one of these cases, I think Court of Claims may refer to this, where it's subsequent conduct which establishes what the parties in fact agreed. Is that the way it's being put?
I'm not necessarily that way, because remember, we do have. Ms. Adams had been engaged on earlier contracts, of which this was the next version.
Yeah.
So they knew how they were operating. They knew what the methodology was. Or would you like to? I'd like to do more shows this year because I want to stay in Glasgow. Okay, how many? How much? That's agreed, and then you suddenly get 20 pieces of pages of paper purporting to set out the terms, but they're not the terms that were actually agreed.
I think, Mr. Gordon, you're really bound by the opening words of paragraph 57. The material parts of Ms. Adams' evidence may be summarised as follows.
Bound or helped, my lord?
I think they bind you. In other words, you can't look for something else.
I would say that they focused on the material one.
Well,
All right.
I was just going to conclude with paragraph 50 because I was.
How are we getting on? How long more?
10 minutes is absolute more than I will need.
Thank you. Paragraph
Paragraph 50
of the UT or?
of the yeah, indeed.
Yes.
I would say that that's no more than a summary of what has gone before it, but I would just like to cover the second sentence of that, because the Upper Tribunal complains that the first tier departed materially from normal principles of contractual interpretation without a secure basis in a realistic, worldly wise examination of written agreement and surrounding circumstances, including post-contractual, to make such a departure possible. I will say that what the Upper Tribunal is doing is either forgetting that autoclaims even operates in this sphere, or giving it an unduly narrow application, because autoclaims tells us precisely that the normal principles of contractual interpretation do not represent the starting point in the world of work. Yes, you have to take into account what the written terms purport to be, but that is only a factor to be taken into account. In short, the Upper Tribunal's criticism of the first tier just simply overlooks what autoclaims and related authorities say. The Upper Tribunal had no basis for setting aside the first tier's decision.
Maybe that you really say they got the law wrong in 48.
The Upper Tribunal?
Yeah.
Yes, and going back to paragraph 40. My lords, if I'm successful, first of all, if I need to be successful on this point, but if I'm successful on autoclaims, then that means that the question that has the hypothetical contracts are those as set out by the first tier, and not the more onerous ones in the Upper Tribunal. And therefore, the finding of the termination of the employment status is, as the first tier said, we've got the hypothetical, just for flagging it up, the hypothetical contracts at 102, 103 of the first tier's decision, at page 175. The first tier then proceeded to follow the orthodox ready-mixed concrete approach. I'll give you the flags. The analysis starts at paragraph 116, page 178. At 117...
Well, you needn't worry about this, because it inevitably follows that if you're right, then the FTT decision stands.
Indeed, but should there be some further issue, perhaps on the application of stage 3, in light of
but Mr. Tolley wouldn't be able to get into that, because he wouldn't have any basis for attacking the FTT, because the basis for attacking the FTT was the autoclaims point. That's the one that succeeded in the UT.
If we win, if your lordships are saying that if we win on autoclaims, that's all we need to satisfy ourselves with, then I'll be happy to sit down. But what I was going to do...
Just give us the reference.
Well, you've got your control point.
It's the control, that's the control point. That's exactly what I'm just trying to
Yes.
Right. Okay.
introduce.
Well, why don't we just go straight to that?
Okay. I'm grateful, my lord. The court has already seen how the control test evolved from being the sole determiner in the days when the worker knew his place to what is now a necessary but insufficient requirement. But what the authorities do not tell us is what amounts to a sufficient degree. Or, if I may put this question in a different way, in what kind of situation does stage 2 reflect an effective and determinative test that can, in appropriate circumstances, obviate the need to go to stage 3? Now, my learned friend highlighted just one case that has turned on the control point, which is the Montgomery case. But Montgomery is an interesting case, not unusual in the employment sphere, involving agency workers. So there the question is, of which of the various contractual parties was the master who was controlling the worker? But in a typical tripartite situation, there's been, to my knowledge, no case turning specifically on control. But as we know, it is still a hurdle that must be satisfied. And the question I will therefore put to your lordships is what amounts to sufficient control to make someone master? Now, I won't take your lordships to it now, but I'd invite your lordships to remind yourselves of what is said at page 179 of the core bundle, paragraphs 118 to 123 of the first tier's decision.
See, I mean, your point is they didn't reach a conclusion.
It's common ground that there was not an express statement.
Right.
What we say is either it is implicit by the words even if, the way they introduce that, or on the findings of fact, if there is no implicit finding and it's effectively up at large as to whether or not there was sufficient control, I would invite your lordships to say there was insufficient control to make one master.
Was this raised by you in the upper tribunal?
Indeed. But remember,
But they didn't need to.
they didn't need to consider it because having swept aside.
That's fine, I just wanted to know that. Yes. Okay.
The summary, which I will take you just for the sake of time, is in paragraph 124. So 123 was good enough. No, what's 123, I mean? Although each hypothetical contract did give the BBC an element of control, that control did not extend to the nature of the other engagements. Given that the control test has to be satisfied and has to be a real test to be overcome, and I would suggest in bipartite agreements as well as tripartite, I would suggest that the findings of fact that are no longer impugned mean that there was not sufficient to be master. I would suggest that the true meaning of the control test must be derived from its Victorian origins of master and servant. And I come up with the example of a gardener employed at the manor house who is clearly subject to the orders of his lordship or his ladyship. But if the butler is indisposed, the gardener can be redeployed at the employer's request. The self-employed, who are engaged for a specific task, have much more freedom to say no. Alternatively, one looks at a medical practitioner. One goes to a plastic surgeon for a elective procedure on a particular place for a particular, on a particular date. The contract will make it clear what the doctor must carry out.
Yeah, well, rather than getting into hypotheticals,
Yeah.
could I have your submission on what the FTT was saying in 122? And can I run a possible interpretation by you to see if you agree with it or not?
Indeed, my lord.
Because it might be thought that the key sentence is the middle one. However, we do not regard that level of control over Ms. Adams' other activities as being a significant factor in reaching a conclusion on the issue which is central in this case. And they go on to give reasons. So a possible interpretation, it might be suggested, is that they thought there was enough control to satisfy stage 2 of RMC, but that it wasn't a significant level of control once you came on to stage 3. What would you say to that?
And I would say that that's not the exercise it's carrying out. This is clearly within stage 2 analysis. Stage 3 analysis doesn't start until paragraph 124. So this, considering the different elements of control, is all being decided in the context of stage 2.
Might that reading not fit with what they say at 124? Even if the existence of mutuality and BBC's editorial control means that each hypothetical contract met the first 2 conditions, then the question is whether the third one is satisfied.
So then it does, what is, sorry, maybe I misunderstood your lordship's question. What the first tier is doing is trying to identify the areas of control. The only area of control is thought relevant at stage 2, having said that Ofcom, etc., was not significant was the control over the job, the editorial control. So that's and the question that your lordships, I'm putting to your lordships, is the editorial control, which was the only element of control, sufficient to get through stage 2?
If they didn't think there was a sufficient element of control, why did they go on to consider anything else? Why doesn't that anybody understands brings the inquiry to an end?
My lord, I would say that it's very common in the First-tier Tribunal, and presumably in the Employment Tribunal,
Of course,
make findings.
Yes, but there isn't a lest we should be wrong.
Well, there's the even if.
Yeah, but that.
Yeah, that's all I'm saying.
As a matter of linguistic analysis, it's ambiguous.
I accept that it's not the clearest thing, but that's the whole point. It's common ground. There was no express finding. But what I do submit is editorial control alone does not get you through stage 2, because otherwise, if it's simply a case of every task provided, every service provider is engaged to carry out a task, there will always, in those circumstances, be the equivalent of editorial control. And if stage 2 is to be a meaningful test, there must be some other questions that need to be addressed. And all the other factors seem to be insufficient. And that's why I would submit that on these circumstances,
I must say, I thought that control over activities outside her contract was likely to be pretty irrelevant to the issue of control. Surely the issue of control relates to what she does under her contract, which is a part-time worker for the BBC. Mm-hmm. The question of control is, in the course of carrying out that part-time work, is there a sufficient element of control? I mean, the fact they can or can't have some restriction on what she does in her own time is of the most marginal relevance, isn't it?
But my lord, if one takes that narrow view as to what sufficient control is, i.e. editorial control is sufficient.
No, not editorial control. There are other things. It's not just that. It's where and when and so on and so forth.
Well,
but you're looking, surely control focuses on the job, not on things that aren't the job.
My lord, but then what the natural consequence of that line of thought is that the control test will always be met. There won't be a situation.
No, that's not true. It ought to, I mean, that can't be right.
In what situation?
But I mean, it's when we needn't. The question is whether, in this case, there was sufficient control to satisfy the requirement for a contract of employment in relation to her work for the BBC. That's what matters.
My lord, my submission is that if one focuses on the idea...
And you say no, there wasn't. That's all.
Yeah. Indeed, and if one says that the control test is satisfied on the facts found by the first tier, in those paragraphs 118 to 123, if editorial, which is only editorial control really, then the control test becomes meaningless.
Anyway, you agree, do you, that it's control in relation to what she does under the contract that matters, not whether there's some element of control as to what she can do in her own time.
I would say that actually each case turns on its own facts.
Well, I know, but what's the point here?
The point here is that the only element of control that was held to exist was editorial control. All other matters didn't. And editorial control is the same way as me standing up and my client telling me how to run my case. Is that, am I caught by stage 2 of ready-mix concrete? Do I have to move to stage 3 to show that I'm actually self-employed?
You are subject to instructions. So if your client tells you not to run a point, you're not allowed to run it.
Does that mean I'm controlled?
So just can I be clear? The finding of editorial control is in 118, is that right?
So 118, yes, indeed.
Yeah.
Right.
But then it's repeated elsewhere, isn't it? It's repeated in summary at 1, 2, 3. There is an element of control. That's the element. Excuse me. Just being reminded, we're in the context of an auto-cleanse approach to the contract, and therefore the right of first call would also not be, Ms Adams would have complete right to choose when and when to serve.
I follow that, yes.
Right, now Mr Gordon, all good things must come to an end. Where have we got to? We're already overrunning the overrun.
I finished, my lord, subject to any further questions your lordships have. The good thing has come to an end.
No, and thank you very much. Yes, Mr Tully.
Just readjust all my bits and pieces there. So, my lord, what I propose to do is deal firstly with the respondent's notice points, auto claims and control, and then make some brief, as it were, reply points on the appeal itself. But obviously be guided by your lordships as to what's useful. I'm always conscious that at 20 to 4, when the conclusion is 4:30, the idea of time being elastic seems to run off. So to the auto claims point, my lord, just for reference, it's HMRC supplementary skeleton at paragraphs 4 to 9. I'm not asking you to turn it up, just to put it in the context of the written submissions. That's core bundle 62 to 66. And as I'm sure my lords have already grasped, this issue concerns clauses 8.1 and 8.2 in the standard terms, which are in the supplementary bundle at page 43. And it's these two clauses that the FTT concluded to not reflect the true agreement of the parties and so excluded from the hypothetical contract.
Supplementary bundle again.
43, my lord.
43. Thank you.
I believe it's in the supplementary bundle, but I'll make sure I've got the reference right.
So page 43, B43 in tab 5.
Thank you.
Yes, in the supplementary, it's at the very top of page 43 of the supplementary bundle. I just wanted to explain one point about the genesis of all of this, my lords, because it's important to correct a misunderstanding for which I'm sure my learned friend didn't intend to create. Below, HMRC didn't make an Atholl claims point at all. So in the FTT, there was no contention for HMRC that any part of the written agreement should be disregarded. I didn't conduct.
HMRC might not have done, but you saying that Ms Adams didn't either.
No, Ms Adams did, my lord. But my learned friend said, well, one of the findings of the FTT was to disregard a provision of the contract in favour of HMRC, namely the substitution clause. And I just wanted to be clear that HMRC never contended in the FTT for the disregard of any provisions of the agreement. I didn't conduct the case at the first tier, but it doesn't matter. The point is that auto claims was introduced on behalf of Atholl House as an argument prior to the hearing. It didn't have much in the way of preparation, shall we say, and it wasn't covered by HMRC's skeleton argument. You can see that in the supplementary bundle because it just wasn't in play at that point. That doesn't make it any the less something that the FTT considered. But I just wanted to make it clear, my lords, that this wasn't a case of sauce for the goose and sauce for the gander, where HMRC must live by the sword and all that. There are two overview points, if I can make them first, please. There's a distinction between what might be described as the auto claims approach and the line of cases culminating in Carmichael. My learned friends sought to draw a parallel. But Carmichael is addressing cases where the written terms are incomplete and one needs to derive from other sources the content of the contract. Auto claims is about departing from the written terms. It's a different matter. And if I can just pick up a point that my Lord Sir David Richards made a few moments ago, all of the written terms which the first tier here found not to exist in the actual agreement were concerned with the BBC's right to restrict Ms Adams' work for third parties. And as my Lord rightly pointed out, that's not actually about control in the relevant sense of ready-mix concrete at all. It's a different point. It's a factor that goes to what might be described as a third stage point, is it a matter in the contract inconsistent with the characterization of it as a contract of employment? And so the existence and extent of any right to restrict work for third parties may go into the analysis at the third stage. But as my lord rightly pointed out, it is not about control in the performance of the contract, which is a separate conceptual matter. I can see, my lords, at an extreme, there could be said to be an overlap. In other words, if one imagined an exclusive contract which was for the provision of the whole of the person's time and prohibited any work for anyone else under any circumstances, then you might say, well, the extent of that provision for exclusivity means that the control, the powers of control of the putative employer are all the more forceful because there's nowhere else for the individual to go. But that's really a very different point. That's really not so much about the existence of control, but about its efficacy.
But why, if you're obliged to work for me for 4 days of the week, why does an extra provision saying, but I can make you work on Friday as well? Is that not to be taken as being an exercise of control? It's not just the third stage, is it?
Well, I can see, my lord, that it may segue into the question of control of
yes, as you say, there may be an overlap in that. I'm not sure that that simply because it's not control over the 4 days of the week,
well,
the existence of a right to make you work on the 5th isn't controlling.
I accept my lord's point that the right of first call argument is to be distinguished from the right to restrict work for third parties point. And I see, my lord, that one might distinguish between 8.1
so far
and 8.2 on that premise. But the arguments that are being advanced here, my lords, in my submission, suffer from this fatal flaw, that it's a misuse, in my submission, by Atholl House of the auto-cleanse principle. Now, before I get into the detail of that, and it'll only take a couple of minutes, I accept what my Lord Sir David Richards says, that in some cases, one will need a reality approach, if you like, to treating the terms of the particular written contract. One will need to look at them with a sceptical eye, particularly in a case, as very often occurs, and this might be an example of them, where the parties to the contract might be perfectly content to characterise their relationship as one of self-employment. But along comes HMRC to say that that isn't how the reality of this agreement should be analysed. And if you like, that need for reality in analysing the agreement between the parties applies whether one calls it an auto-cleanse approach or something else. But just to focus on what auto-cleanse and Uber are about, as has already been raised in the course of submissions, normally a person relying on the auto-cleanse approach will be seeking to disapply contractual provisions which purport to deprive her or him of statutory rights as an employee or a worker. And as my lords have already pointed out in the course of argument, Uber makes clear that this is a principle of statutory construction, intended to ensure that statutory rights are protected. And in the course of the questions that my Lord Sir David Richards raised, if I may so bang on point, the problem with auto-claims was that Lord Clark didn't explain very clearly, it was assumed rather than explained, why it was that this approach was appropriate. And perhaps it was, if you like, obvious from all the citations to cases like Carl Wack and Protect-A-Code and so forth to an employment practitioner that it was all about statutory employment rights, but it was brought to the surface, that point, by Lord Liggett and the rest of the members of the Supreme Court in Uber. My lords may wish to note that the rights being asserted in Uber were rights that derived purely from having the status of worker. It wasn't necessary to establish that it was properly to be regarded as a contract of employment, and indeed that wasn't an issue anymore by the time the case got to the Supreme Court. It had been raised earlier, but by the time the matter got to the Supreme Court, it was no longer an issue whether the workers, in the form of the drivers, that should be regarded as employees also. It was only the worker status, Lim B worker. By contrast, in auto claims, there were a combination of both rights, both types of rights. So some of the rights being asserted were rights deriving from worker status, like the right to annual leave or the right to minimum wage. Other of the rights being asserted turned on being an employee because they were rights to be protected from detriment under the Employment Rights Act for asserting other rights, which in turn derive from having employment status, properly so called. It may just be worth noting that difference between the two cases. But my lords, what's happening here is that Atholl House are seeking to rely on auto claims in order to disapply contractual provisions whose existence would make it more likely that in a direct contract, Ms. Adams would have been treated as an employee. And that's the, in my submission, incorrect use, I'll call it a misuse and won't shy from that, of the Atholl House, of the auto claims and Uber principles, because they're not designed to enable, as it were, a pick and mix approach to contractual provisions in the context that we have here. They're designed to ensure that statutory rights are protected. As I say, my lords, I'm not trying to offer a submission which purports to say that one can therefore disregard the reality of the relationship. That is a relevant consideration.
You say it's not designed to enable people to divest themselves of statutory rights.
It'd be very odd if that were the way auto claims and Uber were applied, my lord. But I do emphasise that in the unusual context of Section 49 of ITIPA, and the Upper Tribunal make this point, and I don't criticise them for this, that when transposing the actual agreement into the hypothetical agreement, it's not a case of just taking and lifting terms and planting them into the hypothetical agreement. One has to consider, in fact, the circumstances. Mr. Justice Mann makes this point in Krista Ackroyd Media as well, that there may be additional facts that are relevant to the exercise of constructing the hypothetical contract beyond the content of the actual contract. And so in that process, there might be room for this kind of argument. But it is emphatically, in my submission, not about treating as absent from the actual agreement terms which are actually there. And the criticism of the Upper Tribunal's approach proceeds on, in my submission, two misconceptions of detail. One is that the Upper Tribunal applied a threshold of imbalance of bargaining power. But two points behind that, my lords. One is that, as I think my lords have already recognised, it was a correct observation that on the facts of this case there was no such imbalance. And secondly, auto claims itself makes it clear that imbalance is a relevant consideration. So when one looks at Authorities Bundle 2, tab 22, and that's page 449,
This is in auto claims.
this is in auto claims, my lord.
So paragraph in auto claims.
Paragraph 35 in auto claims, 449, your lordships have just seen this,
Yes.
where his lordship, Lord Clark, says the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement in truth represent what was agreed. And the question I suggest, my lords, is really what my learned friend is trying to do, is to leave that part of the sentence out of account and just take the second half of it. And to say, well, even if there isn't an imbalance in bargaining power, nonetheless, the true agreement will often have to be gleaned from all the circumstances of the case of which the written agreement only forms a part. And my lord, that's to separate the operation of the principle from its underlying foundation.
One might plausibly then say, might one not, that in a case where there's no imbalance of bargaining power, the agreement is the more likely to represent the agreement between the parties.
Quite so, my lord.
So whereas in some circumstances imbalance may pull you away from the agreement, particularly if it deprives people of rights which they would otherwise expect. In other circumstances, it might pull you towards the agreement.
Yes, quite similar. Thank you. So the second submission that my learned friend advances is that the Upper Tribunal imposed a threshold of unrealism, that the written terms should be unrealistic before one can depart from them, and that was an error. But there are at least 4 places in Atholl Claims itself where the focus is on the reality of the situation. Let me just quickly show my lords. At 445, paragraph 22, and Lord Clark, his lordship, there introduces the history of recent cases at that point, where the courts had held that the tribunal should adopt a test that focuses on the reality of the situation, where written documentation may not reflect the reality of the relationship. And then one sees what that unpacked a little means from the judgment of Mr. Justice Elias, sitting at first instance in Calwack, as then he was as the High Court judge. And one sees at 57 at the bottom of page 446 of the bundle, the concern set out there, internal 57, is that armies of lawyers will simply place substitution clauses or clauses denying any obligation to accept or provide work into employment contracts as a matter of form, even where such terms do not begin to reflect the real relationship. There's a quotation from Lord Justice Peter Gibson from Tanton about the reality of any obligations, and that was the case about the substitution clause. And 58, in other words, if the reality of the situation is that no one seriously expects the worker will seek to provide a substitute, etc., then the fact that the contract expressly provides for these unrealistic possibilities will not alter the true nature of the relationship. But if these clauses genuinely reflect what might realistically be expected to occur, then the fact that the rights haven't been exercised won't make the rights meaningless. And so it couldn't be clearer in my submission that the underpinning for this type of analysis is a finding by a tribunal at first instance that the terms of the contract have been dressed up, short of a sham, not a dishonesty, not a rectification case, just clauses put in as a matter of form to make it look like one thing when the reality is that it's another. And so putting provisions in a contract for car valeting that individuals are in business on their own account and self-employed and so on is, as it were, on its face, and in light of the evidence, a surprising one. And the tribunal judge so found. In Protecticoat, it was about window cleaners who were made to enter into agreements looking like partnerships. You had 2 window cleaners in a partnership with each other, purporting then to provide services to Protecticoat. And again, the Court of Appeal, and following at first instance, said, well, that was all just unrealistic. That's not what the true nature of these business relationships were. Then moving on to paragraph 29, on the following page of this bundle 447, one sees Lord Clark specifically endorse preferring the approach of Mr. Justice Elias in Calwack, and the Court of Appeal in Shillaghi, that's Protecticoat, to that of the Court of Appeal in Calwack. And the Court of Appeal in Calwack had said it's the snook sham test that applies. In other words, there has to be an intent by both parties to deceive a third party. Whereas Mr. Justice Elias in Calwack and in the Court of Appeal in Shillaghi had made it clear that wasn't the relevant test. And then lastly, my lords, on page 449, paragraphs 34, your Lords have just seen 35, so the only reference I need is 34, is the quotation from Lord Justice Aikins in the Court of Appeal, last 5 lines. In this area of the law, more common for a court or tribunal to have to investigate allegations that the written contract does not represent the actual terms, and the court must be realistic and worldly wise when it does so. So that's the realistic and worldly wise phrase that pops up in the Upper Tribunal's judgment. And what it said was, well, disregarding these terms, from the actual agreement is the very opposite of the realistic and worldly wise view that Lord Justice Aikens called for. These are terms that can and should realistically be treated as part of the actual agreement, because one can consider that the BBC might need to rely on them, might want to rely on them, even if normally speaking it wouldn't have to. So in short, my lords, there wasn't any error in this respect by the Upper Tribunal on the Otto Clinton's point. It was the first tier that went into error by applying the approach in the first place, and secondly by misapplying it without a proper foundation on the basis that the written agreement failed to reflect the true agreement. Essentially what they relied on was that the witnesses didn't recognise these terms, but then Ms Adams said she never read them. And Mr Patterson wasn't responsible for preparing the contract. He was a programme producer. You wouldn't expect him to know about the terms. The whole of the FTT's approach went off on the wrong basis, my lords, and so the Upper Tribunal was right to interfere with it in disregarding these clauses. But if I'm wrong about that, and my lords considered that the FTT's approach should be upheld, then what I say in response to control is that there was still a sufficient framework of control in the performance of the services. And I refer my lords to paragraphs 10 to 14 of the supplementary skeleton, that's pages 66 to 67. I've made the point already, but I do accept my Lord Justice Peter Jackson's comment that there's a distinction to be drawn between 8.1, the right of first call, and 8.2, the right to restrict work for third parties. 8.1 is more about control in the performance of the activities. 8.2, the contractual activities. 8.2 is rather concerned.
The point it could apply to both. So the UT says that the first call right can be regarded as having two parts. One, performance of the contract itself, and also it has an impact on performance of other activities.
Quite so, I accept that, my lord. But my point is it's important to be clear what we're talking about in the context of ready-mix concrete structure. When one's talking about control, I respectfully endorse what my Lord David Richards said, that the control is concerned with the performance of the contract and not with the restricting activity for third parties. And so the first answer I offer to my lords about this is that on an appeal from the Upper Tribunal to this court, the correct function of the court is to determine whether the Upper Tribunal erred in law rather than whether the first tier erred in law, and the authority for that is Pendragon. Just for my lord's note, that's tab 28 of bundle 2, and the paragraph is paragraph 51 on page 544. And so the question is whether the Upper Tribunal's approach to control was wrong. But even if ultimately my lords get to this point in the analysis, and the question is whether on the premise of the FTT's findings only there was sufficient control for the purposes of ready-mix concrete analysis. There are a whole lot of cases I could show my lord, but I'm conscious of the time. I think I'll just pick one, if I may, for now, which is the case of Christa Ackroyd Media and the Upper Tribunal, because it highlights the point, for the purposes of this case, very neatly. So that's in bundle 3 of the authorities, tab 40. My lords have the head note at 876. And there are two references in the judgment. Paragraph 54, first of all, at 895. I understand, my lord. Yes, of course, my lord. Page 895. Here, His Lordship Mr. Justice Mann was addressing the submission about the meaning of a sufficient framework of control, that phrase in Mr. Justice Buckley's judgment in Montgomery at 19. And the submission for Krista Ackroyd Media was that that was a reference to the contractual mechanics. You can see that 3 lines down in 53. Contractual mechanics, conferring on the recipient of the services a method of enforcing control. But the answer to that at 54 of the Upper Tribunal was, we do not consider that His Lordship was addressing the granular mechanics of control in this context. There's no discussion which would indicate that particular performance tools, such as appraisals or line managers, were material. And ultimately, they go on to say that the real point that was being made was about ultimate authority, rather than the exercise of any right of control on a day-to-day basis. And they picked it up clearly from White and Troutbeck in the Employment Appeal Tribunal. My Lord saw this passage yesterday, where His Honour Judge Richardson makes it clear that it would be rather surprising if somebody who was engaged, to use that word neutrally, to look after somebody else's farm was not under a contractual obligation to accept instructions about how that should be done. Even if the contract was silent, one would implicitly understand that that's the premise on which the parties are contracting with each other. And then the second point is at paragraph 59 over the page, so bundle page 896, under the heading in inverted commas, regulatory control. And the argument for Krista Ackroyd Media was that control which applies to both employees and non-employees cannot be a touchstone of employment. And at 59, the Upper Tribunal analysed this argument as either being a submission that the obligations imposed on Ms. Ackroyd were irrelevant because of the BBC's reasons for imposing them, or because since the obligations that the BBC had applied to all content providers, they weren't properly part of the ultimate control, the context in considering ultimate control. And His Lordship says, we do not accept either argument. And indeed, he goes on at the end of the paragraph, last 4 lines, to say that they consider that the FTT would have been wrong to leave the guidelines out of account because of their potential application to other service providers.
But in this case, there had previously been an instance of very obvious control when there was a suspension.
Yes, it was under an earlier iteration of similar terms.
As demonstrating control of a quite fundamental nature, where there had been a...
It's what the BBC considered to be an infraction.
Yes, and they took action. Miss Adams accepted it, and on they went.
Quite so, my Lord. Nobody's suggesting it was the sort of thing as to bring the relationship to an end, but it was, as my Lord says, an exercise in the BBC's right to determine what was acceptable and what was not, whatever other person's opinions might have been about it. But I just wanted to unpack 2 arguments, 2 separate points from paragraph 59 in Krista Ackroyd Media, if I may, because of the correct analysis, if I may say so, of the Upper Tribunal about it. So-called regulatory control can be objected to on the basis that because it is being imposed in order to comply with an obligation to a regulator, therefore it's irrelevant. And so that's irrelevant to the question of whether the contract in which that control is imposed is one of employment. And the Supreme Court in Uber emphatically rejected that argument because one of Uber's points was, well, we're only doing what we do in relation to the drivers to satisfy our regulatory obligations as an operator of private hire vehicles. And so that...
But isn't the point here more that in the context of the BBC, one would assume that a requirement to comply with Ofcom regulations would be as much a part of a contract of services as it would be a contract for service.
Yeah, I understand what my Lord means.
I mean, it would equally apply to an independent contractor presenting a show once a week, wouldn't it?
Quite so, my Lord.
So it really doesn't, isn't that the idea? It doesn't tell you very much about control in the context of a broadcaster.
what I would say, my lord, is that the question merely of compliance with the BBC editorial guidelines or the Ofcom rules, it does fit within my lord's point. In other words, that doesn't help you distinguish
Yes.
between an employee and a contractor for services,
Yes.
because the same rules apply to both.
Yes.
But what was in addition present in this case were the contractual rights that the BBC had to direct the provider of the services, obviously it was Atholl House, and in the hypothetical contract, Ms. Adams, about...
Yes, so this wasn't a contract that simply said, thou shalt comply with Ofcom guidelines.
Quite so, my lord.
It went rather further.
It went much further, and if I can just give your lordships one example, but the Upper Tribunal has all of these points in its judgment. In the supplementary bundle, my lords will see at page 41 that clause 3.24 requires the company to procure that in providing the services the contributor, Ms. Adams, will attend at such times and places as the BBC deems reasonably necessary. Just by way of an example. That's a specific contractual provision that entitled the BBC to determine when and where the work would be done. 3.26 included fully and willingly to comply with such requests as may be made by the BBC in connection with the services. What I'm trying to emphasise, for my lords, is that the debate about control didn't turn in this case on simply the application of the BBC's editorial guidelines. There were significant indications in the contract itself that there were contractual rights of control, and all that the regulatory position added was this important point, that you would expect the BBC to want contractual rights of control, because otherwise how could they be sure to satisfy their regulatory obligations vis-à-vis Ofcom? Because they had no right to direct
in
a
the first
presenter.
instance, it's the BBC that is taking the action in order to comply with what it perceives to be what Ofcom requires.
Yes.
I mean, there is a measure of discretion as to whether a certain incident merits any sanction or not, and that's something that the BBC has to decide for itself.
Quite
It
similar.
may or may not be right that it's a breach of a statutory requirement.
But I accept what my lord says. My only point by way of addition is one can understand why contractual provisions of this kind end up in the contract and are real, because there may be circumstances where the BBC finds it necessary to exercise them.
Yes. Okay.
That's the only point. So all I say ultimately, my lords, is that what happened here was the Upper Tribunal correctly applied the established legal tests on the question of control and had arrived at the correct conclusion. But even if one excludes from consideration, for the purposes of analysis, clauses 8.1 and 8.2 of the standard terms, and says, well, the Upper Tribunal got it wrong on its auto-cleanse point, the question I, as it were, invite this court to consider is whether, even on that premise, the BBC would still have had a sufficient right of control to satisfy the second stage and ready-mix concrete. And one can see from the contract itself, and indeed the Upper Tribunal's analysis here, that the right of control was sufficient. And indeed, if you go back to the First-tier Tribunal's decision, as my Lord Justice Arnold did, one sees that the First-tier Tribunal considered that there was a right of control in respect of the performance of the services. Then they went on to consider the right of first call and the right to restrict conduct with third parties, and concluded that those provisions weren't in the actual agreement. But if you took that section out of the FDT's, sorry, let me put that differently. If you test the question of control on the premise that those clauses don't belong in the actual agreement, there's still a sufficient contractual right of control for the purposes of the relevant term. So, my Lord, I've got a few points to make by way of reply. I'm going to make sure I focus and don't put anything unnecessary to my lords. 4 points by way of overview first. Whatever my lords decide about the correct approach to the test on whether a contract is one of employment, it needs to be applicable throughout all the disparate areas in which it will need to be used. And that includes tax, employment, health and safety, and of course vicarious liability. And so what I submit to my lords is whatever test one does use, it needs to be workable and effective in all those different types of cases.
It also needs to work for workers of all sorts.
Quite so, my lord. And my essential submission to my lords is that the value of the ready-mix concrete approach is that it brings everything relevant in while leaving nothing of relevance out. In other words, but it also applies a structure that enables one to test different aspects of the relationship in a rigorous and analytical way. The second point is about using the metaphor that's been deployed throughout this hearing, the need for a frame. And my submission essentially in response to my learned friend's argument is that having a free-for-all, the way I would characterise it, of each first instance fact-finding tribunal, whether that's the first tier or the employment tribunal or the county court or even the high court, having to determine in every case what is or might be relevant, is likely to lead to the very opposite of what Mr. Justice Buckley called for in Montgomery, which was the search for clarity and predictability. In other words, he says, unless the search for those virtues is to be abandoned altogether, one needs to have some sort of coherent test. And so it can't just be, well, let's consider everything approach and see where it falls out. The third point I'd offer, my lords, is this, that one should avoid assumptions. Two aspects to that submission. One is that people who work do not have a permanent employment status. The status derives from the terms of their engagement and the work that they do. It's not that they acquire the status and that carries through their working life regardless. And the second point is that there isn't a special rule for any type of work. In other words, actors, plumbers, or even radio presenters are not a special case. They may or may not be employed. It all depends, in my submission, my lords, on the terms of their engagement and the relationship between the parties. I wanted to make one further point about the Upper Tribunal's error in respect of HMRC's alleged concession. I know my learned friend didn't dispute it, but I just wanted to...
Your fourth point was no special cases.
No special cases, quite so, my lord.
Okay, so we're now on to...
I'm just adding a fifth point about the Upper Tribunal's error about HMRC's concession, allegedly, that the first 2 years that had originally been in dispute had been dropped because they were properly to be regarded as self-employment rather than as employment. My lords already have the points on that. My learned friend doesn't dispute them. But the aspect I wanted to draw to my lord's attention was that if one looks at page 72 in the core bundle, paragraph 2 of the Upper Tribunal's decision, one sees that the error appeared actually there in the first place. In the second line, shortly before the hearing in the FTT, HMRC accepted that the legislation did not apply in the 1314 and 1415 taxes. Well, no, it didn't. And that's the error that gets repeated at paragraph 115, page 109, with reference to paragraph 3 of the FTT's decision, which didn't say anything of the kind, and it wouldn't have said anything of the kind because that's not what HMRC had done. The second point the second area I want to cover in reply is the question of whether or not Hall and Lorimer is an application of ready-mix concrete at the third stage. I'm very conscious of my Lord Justice Peter Jackson's point is essentially, why does it matter? I know my Lord didn't put it like that, but that's the way I'm paraphrasing it. And if I may say so, that's a perfectly fair and indeed important observation, because this is a case, I would say, my Lords could decide if they wish to do so without troubling themselves about whether Hall is or isn't an instance of the application of ready-mix concrete. In other words, the errors that the Upper Tribunal made at the third stage are errors, whatever view one takes, in relation to that general question of legal principle. But just in case it assists my lords, I just offer these further points in terms of answering that question about whether Hall is an application of ready-mix concrete. As to Hall itself, it contains no hint that that was the analysis at any stage of the case. So the Special Commissioner's decision, equivalent of the first tier, wasn't based on ready-mix concrete at all. It was based on market investigation. So one sees the first tier's decision, the Special Commissioner's decision, included in the report of the High Court decision. So tab 10 in the High Court decision of Mr. Justice Mummery, one sees included in it the Special Commissioner's decision. No reference to ready-mix concrete at all. Secondly, in the High Court, although His Lordship Mr. Justice Mummery mentions ready-mix concrete, he then goes on to apply market investigations as the business on account test, being supposedly fundamental test. And then thirdly, when you get to the Court of Appeal, the judgment doesn't mention ready-mix concrete at all. Although it was obviously cited to it, as my lords have seen, it doesn't feature in the judgment. So it's difficult to see how one can say that Hall is an instance of the application of ready-mix concrete when none of the judges at any of the stages in the case said or recorded that that's what they thought that they were doing. And as I've sought to explain to my lords, it is a different approach. And the two further points I'd add, if I may, that in Fall and Hitchin, there was that important passage in the judgment of Vice-Chancellor Pennycook that it's perfectly possible to have simultaneous employment and self-employment even in the same sphere. And that very passage is approved by the Court of Appeal in Hall and Lorimer. And so the reference for that is bundle pages 258 to 259. And the error that the High Court found in Fall and Hitchin to have been committed by the General Commissioners, the first instance tribunal there, was to have reasoned from the general to the specific. In other words, to say, well, because Mr. Hitchin was generally trying to make a career for himself as an actor and a dancer on a freelance basis, so it followed that the contract he'd entered into with Sadler's Wells was also a contract on the premise of self-employment. Whereas, as Vice-Chancellor Pennycook pointed out, you need to focus on the terms of that contract to see what its true nature is.
Can I try and understand what you're saying? That you say you win regardless of which test is used. You say that if one treats them as being different approaches, RMC and Hall and Lorimer, that it's open to this court to say, appeal allowed, whatever. That was one point that you made, as I understand.
Yes, my lord.
Which means we've been listening to an awful lot of argument, which won't find any conclusion in our judgments. But if we were to feel that that was an unsatisfactory state of affairs, what is your submission then as to what the relative statuses are of those two decisions?
My essential submission, my lord, is that, as it were, if there is a contest, I'm not sure that there is, but if there is a contest, then ready-mix concrete is the winner, because it's been endorsed at the highest level to the Supreme Court standard. Nobody, however, in my submission, and I've made this clear, my lords, has ever said judicially that Hall and Lorimer is wrong, and it's no part of my case, to my lords, to submit that it is wrong. All I mean to emphasise, my lords, is that if there is to be a preference for one approach over another in terms of efficacy, and more likely to be useful in the vast majority of cases, the ready-mix concrete approach is that approach.
Well, I understand, and if your submission that Hall and Lorimer didn't think they were applying ready-mix concrete is persuasive, as well it might be. Is there a third way, which is to look at it and say that actually, provided one has a proper structure, all the considerations that are to be found in Hall and Lorimer are, by and large, readily find a place within, certainly at the third stage of ready-mix concrete, and that one can therefore synthesize in that way without doing any violence to anybody.
My Lord, I'd be content with that way of putting it, with this qualification, if I can offer it as a qualification, perhaps more of a proviso, that one needs to still be careful, at least in analytical terms, in distinguishing between factors that derive from the contract or the relationship between the parties.
Well, we still then have the argument about the width of the frame. I understand that.
Yes.
But provided there is sufficient structural rigour to the approach and an appreciation that there might be some things that are not within the frame or even on the wall, in those circumstances, that, speaking for myself, strikes me as being something that we would want to consider as a possibility that is actually helpful, rather than allowing these references to simply be picked up by happenstance as cases go on.
Quite so, my Lord. Certainly no part of my submission to invite my Lords to disregard anything that my Lords consider to be relevant in the approach to identification and
rigorous
characterization.
synthesis. Right.
I'm content with the synthesis, my Lord, but provided one's clear what one's up to. And then the last...
Saying that you had to be, you did your proviso was that one had to be careful, as you said, about factors deriving from the contract.
So in other words, what I say, my Lord, and my primary submission to my Lords is that what the third stage of ready-mix concrete analysis is about are contractual terms or provisions which are inconsistent with the conclusion that the contract is one of employment, or, putting it in the other direction, terms that are consistent with the contract being a contract for services. You have to look at it either way. And that, as it's been expressed in some of the cases like Quasi, puts it in terms of the employment relationship or the work relationship. And I accept, my Lord, that that way of putting it certainly encourages one, and this I say is the right approach, to look beyond the mere question of what the contract contains and to look at its effect in terms of its necessary effect. In other words, what's bound to happen as a result of this contract? If one has a contract, as here, in my submission, for 160 separate occasions of work, each of them, as it were, a substantial piece of work in its own right, and a minimum amount of payment for all of that work, that's bound to produce a certain amount of dependency as a matter of economics, and to take up a certain amount of time as a matter of doing the work. So after all, we're talking about an individual's work. It's not about delegating it to anybody else. That's to be distinguished, in my submission, from a situation like Trust House 40 in O'Kelly, where it just so happens that there's a lot of work, but there is no contract at any point that ever says that large amount of work is to be done. So looking forward from the contract, you never see more than another day in any contract in O'Kelly. Whereas looking forward from the contract, in this case, one sees the prospect of 160 occasions of work. And that's the essential distinction. Excuse me. So just before leaving this point, my Lord, two final things. One is that in the more recent authorities, in which category I will include Quasi, PGMOL, and Uber, nothing is said in any of them about applying a business on own account test in its own right. And secondly, that can I just leave my lodge with this reference? Paragraph 35 of HMRC's skeleton argument for the detail as to why we say that Follen Hitchin shows that the Upper Tribunal's approach here was incorrect in terms of reasoning from the general to the specific. In other words, reasoning from the general proposition that Ms. Adams was in business on her own account to the specific conclusion that this was a contract of self-employment. Well, I think I've only got 2 other points. I'm going to make them very quickly given the time. The first is to clarify my submissions in respect of Synaptech in light of my Lord Sir David Richards' questions yesterday. My Lord suggested that paragraph 20 indicated the need to take into account the fact of business on own account, and we had an exchange about how one should read that. And I just wanted to explain to my Lords that having gone back to the case, and I give my Lords the references, where one sees the General Commissioner's findings at 5.1, 5.2 and 5.9, and that's at pages 334 and 335 of the bundle, it appears that what Mr. Justice Hart was getting at paragraph 20 must have been a reference to that material, because he refers specifically to 2 of those paragraphs and probably had in mind a 3rd. And the consequence of all of that, my Lord, is that my Lord's observation is a fair one, that Mr. Justice Hart must have had in mind Mr. Stutchbury, as he was, the individual's dealings with third parties, and not Mr. Stutchbury's dealings with this particular client on the same contractual relationship as the one that was an issue. Because those paragraphs are about working on the weekends and in the evenings for other clients. And so what I seek to make clear there for my Lords is that my submission about paragraph 20 is as follows: that the mere fact of being in business on one's own account should not be treated as an important contextual circumstance, because it's difficult to see how it sheds any light, of any use at any rate, on the question of status deriving from a particular contract that's been entered into. But I just wanted to make it clear to my Lord, particularly in light of the questions, that I couldn't sustain the submission that I made yesterday about reading paragraph 20 in the manner that I suggested. And the last point I wanted to make, given the time, I've got other things I could have said, but let me just make one final point, if I may, that as to the question of economic dependency, so in the context of dealing with particular factors at the 3rd stage, where does economic dependency fit in? As I've sought to explain to my Lords, it's a question of the product of the contract that matters, not mere happenstance. And it's important not to get sidetracked by any question of relative dependency. In other words, if one surmises 2 individuals entering into the same engagement on the same terms for the same work with the same engagers, let's make it as neat and tidy as possible. In my submission, they shouldn't have different employment status according to the proportion of their overall income which they earn from that contract. Because that's pure happenstance.
That depends on something which is quite external, namely their other income.
Quite so, my Lord, and they may or may not be willing or keen to do other work. It might be enough for one person and not enough for the other, but it shouldn't have anything to do with the classification of the contract.
So, just to be clear, as I understand it, you would say that in the instant case, therefore, what matters is the fact that it's 160 days over 12 months for £155,000, not the fact that it's 70% or whatever the percentage was of her overall earnings. Exactly
so, my Lord, if I may say so. And the final sentence in this context is just to try and tie the threads together, that it was suggested that, well, by my learned friend, well, how can you imagine any terms of a contract that would be inconsistent with the conclusion of a contract of employment once you've got past stages 1 and 2? But if you like, ready-mix concrete is perhaps the very best example of that very conclusion. That his lordship, having found that there was work-related mutuality and an element of control in the relevant sense, found that an analysis of the terms of the contract overall led one to the conclusion that it was a contract of carriage. So I'm conscious, my lords, we're already after 4:30, and my learned friend may still want to say something more if my lords permit it, but unless my lords have anything specific that they wish to raise, those are the reply submissions I would offer.
Thank you, Mr. Tolley.
Could I just to be absolutely clear about this, I think we've got to the position that you accept that it may be relevant at stage 3 that the worker does carry on business, let's say, as a self-employed person, I mean, maybe through their service company. You would say that it's overall not likely to be an important factor, but would you accept that in a case where looking at the contract and the circumstances, you're in a rather borderline case, it's a factor that might assume a slightly great, I mean, the question of weight is very fact specific, but it's in those circumstances that the existence of the ongoing self-employed work may have a significance as to whether this particular engagement is employment or not.
The way I'd like to respond to that suggestion, my lord, is as follows, that what really matters and what ought to be focused on are the terms on which that particular engagement in issue has been entered into, and what that tells you about the nature of the relationship between the parties who've entered into it. I do accept the proposition that the background of both parties in entering into that contract may be relevant to understanding the relationship created by that contract, so far as that's factual matrix material.
Yes.
As a matter of general contractual analysis.
Yes.
What I object to, and where I, as it were, in submissions terms, I seek to draw the line, is that if you are simply talking about a kind of subjective intention of career history, I am a self-employed person normally,
Yeah,
and therefore I would like to go on being a self-employed person, that somehow carries through into the proper classification of the contract that is entered into on terms which are indicative of
Because you could have a dispute between the parties to the contract as to whether the worker was employed or self-employed, because obviously the obligations of the parties in terms of, for example, provision of equipment will differ. And so, as you say, as part of the factual matrix in determining whether the relationship is one of employment or not, the fact either that the worker does carry on a self-employed business in the same field, quite important, or not, could at that point be relevant to concluding what the relationship is and therefore where the obligation to provide equipment lies.
I suppose in interpreting the contract, my lord, one could see how that...
The question would be, do you imply a term, if you like, that it's to be the client or the worker that provides the equipment? And that will itself depend on whether it's employment or not. And and you would look, wouldn't you, in those circumstances at the factual matrix, which would include the fact that the worker did carry on business as a self-employed plumber.
I follow the premise of my lord's question, if I may say so. I would suggest that in that context, the question of who was to provide the equipment might depend to a greater degree on previous dealings between the parties.
Well, they never dealt.
If they had never dealt with each other before, then one might consider what the reasonable expectations of the
That would depend on the factual matrix.
It would, my lord. But if let's say the party who was going to do the paying for the work knew nothing about that history, then it wouldn't shed any real light on what their reasonable expectations were.
That would be quite difficult. Yes. Yes.
Excuse me. I'd perhaps like to leave my lord with this submission, that having a status of self-employment or being in business on one's own account doesn't have any kind of presumptive force.
No.
in terms
I
of
mean,
the
I
analysis of the
understand.
contract.
I understand. But yeah, okay,
I'm grateful.
thank you.
Thank you very much.
Yes. Now, don't be troubled by the time. Reply on the respondent's notice.
I'm grateful, my lord. I will nevertheless aim to be very brief.
Thank you.
On the auto-claims point, my learned friend suggested we were taking a pick-and-mix approach. But I would actually respond by saying, just because auto-claims line of authorities has evolved from cases where individuals assert their employment rights and assert that they are truly employees, does not preclude, in appropriate cases, the auto-claims approach applying when it's the other way around. If I could just cite paragraph 29 of auto-claims, the question in every case is what was the true agreement between the parties. It doesn't turn on the reason the question is being asked. Similarly, on auto-claims, my learned friend highlights the references to reality. I think he gave 4 examples. I would just ask your lordships, when looking at those examples, to recognise their context. Without taking your lordships to it, in paragraph 22, the context is made clear by the opening line of paragraph 23. We're talking about the historical cases. In the other examples, the best example is by looking at paragraphs 29 and 30, that the response is, yes, reality is a question, but ultimately, what is most important is, it's paragraph 30 where there's Justice Elias referring to the reality of the obligations, but then, as Lady Justice Smith said, the kernel of all these dicta is whether or not the words of the written contract represent the true intention. So the reality was merely a stepping stone, it's not a precondition. And the same with the other references my learned friend takes you through. My learned friend says that the question for this court is not what the first-tier tribunal did, and whether the first tier was in error, but whether the upper tribunal applied the correct decision. And they rely upon Pendragon for that. But my lords, my submission is that the upper tribunal can only make a decision once it has found an error before. And your lordships would have been
There's lots of authorities that make that point.
Indeed. Moving on to the control point. Just 2 quick points. Again, my learned friend made submissions based upon the findings of control by the upper tribunal. We're not disputing that. On the findings of the upper tribunal, on the basis of the facts remade by the upper tribunal, we concede the control point, and our case turns on stage 3. Our submissions on control are predicated on the first tier's finding of facts being reinstated. And then my point on Pendragon applies equally. And subject to anything from those behind me, the only other point I would like to bring to your lordship's attention is you were taken to the discussion as to how the control test works in Ackroyd, Mr. Ackroyd, paragraph 55 in particular. All I would ask your lordships to recognise is that, obviously, principles I'm not going to dissent from, but there were very extreme facts, very onerous conditions, which I've already alluded to, and therefore the upper tribunal's guidance in Ackroyd must be read in the context of the facts of that case. My lords, I have nothing unless your lordships have further.
No. Well, thank you very much indeed, Mr. Gordon. Thank you both, and everyone who has supported you in the preparation of the appeal. Inevitably, we'll take time to consider our decision and let you have it in writing in the normal way for your editorial corrections, please, and a draft order reflecting our decision. If there are any matters that you can't agree amongst yourselves, then could you please let us have very short submissions so that we can deal with those on paper, and the judgments will be then handed down and placed on the internet in the normal way without the need for further attendance. But, I repeat my thanks.
Very good.